do you mind staying it for, I don't know, 2 weeks, 3 weeks? We're going to speak to Watsons and say to them, instead of us defending for you and you defending yourself and against us and having a load of legal fees between us during the case, can we, between us, can you take it over Watsons? Because you did do it all, and then obviously you can defend it and we can just step out and we save half the legal fees. No,
Watsons won't fit into the claim like that. It doesn't have a direct claim against Watsons. That's the point.
Yeah, I know, but Watsons could do all that. Why could they not run the defence? Why would they not do
that? Because there isn't a claim against them.
No, I know, but what if they were joined? I think James wanted to go visit the what do you call it as well, the substitution thing.
Substitution won't work. Substitution is, for example, if there's a slip up with the name of a company, and you say actually it shouldn't be it shouldn't have been BP, BR PLC. We actually meant BP. Please, can we substitute this? It's a different name, but it's the same. It was meant to be the same people. So it's where you slip someone into the same position.
Sure. If it was a mistake, surely it'd just be an amendment of particulars, wouldn't it? I don't see what that is. It's a substitution of a party.
Okay.
And what it says.
Listen, Ed. Okay, Ed. If you're not going to listen to responses, we're not going to get. So
the problem is, right? What's happening is.
Okay. Can I just stop you there because council's just about to join the call. You have also on the call Ed, who I understand is who works with James, but isn't a director of or actually have anything to do with Mimco. James has sent me an email asking if Ed can participate in the call.
They are a defendant. You don't get to choose whether you're a defendant or not. A claim is brought against a defendant. It's the claimant's prerogative to bring a claim against whichever defendant it wishes to bring a claim against. The proper approach here is not and cannot be to ask the court to substitute Watson in place of Mimco. It will fail, and I'm not able to draft an application for substitution. And I certainly wouldn't go to court to argue it because it's unarguable. It will fail. And there is a potential for a court to make a wasted cost order against the legal representatives who allow such an application to be brought and argued. It doesn't work. It is not a case in which we can say liability is past, liability is with the pre-existing or the previous board of directors, or liability is passed to Watson. Liability doesn't pass in that way, unfortunately. I'm sorry if I'm saying this in a strident way because I've already set it out in writing, but I appreciate it may be a miscommunication.
If the liability falls on Mimco and Watsons were it's hard, isn't it? Because they're a secretary, potentially a director, maybe not. They're an officer of the company, or are they, administrative, whatever. Effectively, were they acting as a shadow director in any event? And surely, let alone the liability passing, the liability is with Watsons, who.
Sorry. I'm really sorry to cut in, and it may be that some of. I appreciate that I've been sending documents across to Emma, and Emma obviously has to pass that on to a client. That's just the way it works. I wouldn't send things directly to a lay client unless there is real urgency and I've got no way of obtaining instructions. But I'm really sorry to interrupt. That's just, we can't talk about liability passing. And the way to look at this, and I use this example whenever I'm talking to solicitors as well as to clients, lay clients, is that if a claim is brought against a client of mine and actually the person who should be responsible for that is a different entity, then you're pointing the finger at somebody else, which is perfectly fine, but you bring them into proceedings, you bring them in as a defendant to your own claim, and you say that whatever's happened, maybe it happened, maybe it didn't, we don't know, or we do know, or we agree that it happened, we agree that the claim as the claimant has pleaded, X, Y, and Z happened. However, it's not us. We're pointing the finger at somebody else, and that person is now going to be a defendant to our claim, and that's called a Part 20 claim. It's an additional claim, and it's essentially two claims joined together with each other. It's the original claim against by sides against Mimco, and it's a second claim, which is a claim by Mimco against Watson, and they've joined. You don't have Watson being parachuted in, because it just doesn't work like that in civil litigation. Now, if Mimco was, if Watson was acting as a shadow director, I believe they were actually appointed as a director. It may be that they resigned, but it may be they carried on acting as a director, in which case, yes, they might well have been for a long time. They might have been a shadow director, but the claim is brought against Mimco, the company, and if one of Mimco's secretaries, officers, or members, or somebody else might have been liable, they are not Mimco. That works two ways, because whilst Mimco was, whilst there were previous directors of Mimco, whilst it might have been that individual director, and I think I've previously listed their names, it was Miss Armitage or Mr. Sollitt, Mr. Pickford, one of them or somebody else, if they were purporting to act for Mimco by permitting Watson to do something, for example, I don't know, but let's say they would have been acting, almost certainly, they would have been acting in their capacities as directors of, or director of Mimco. There may well be a claim against those individual directors. It may be they breached their duties to Mimco.
Yeah, I don't think they did.
Well, we don't know. But, okay, well, yeah. Fine. Well,
I get that. I get all that totally. But what I think it looks to me like we're going to have to agree to disagree, because for me, if you're substituting another party because it's just wrong, then it'd be a sort of, it's a different thing. This actually specifically mentions liability passing. So on the CPR,
I'm sorry, we can't agree to disagree, because I'm right, unfortunately, on this one. I wouldn't, if there was a chance, because obviously I've got Mimco's interest in mind firmly, because Mimco is my client, and if there was even the slightest possibility of Mimco being able to ask the court for Watson to be substituted, then I would be telling Mimco that now. There is absolutely no possibility whatsoever. The only way that Watson can become a defendant to this claim is if that she wants to bring a claim against Watson and not Mimco. Yeah, and that is my firm advice. Now, as I always say, when I was training, I was told this as well by my pupil supervisor. If that's my advice, it doesn't have to be taken. It doesn't have to be accepted. But if that's the case, then what I meant was, why would we not just make an application to substitute, or in the alternative join? Because as you said, you can't refuse to be a defendant. It's just off. You can't do it. If somebody wants to go against you, they're entitled to do that. And yes,
then
you can say you shouldn't be a defendant. Sorry to cut in again there, because I have considered all of these issues. I mean, I did have to refresh my memory, but I started looking at this about a month ago, but I'm back on top of the papers. You can say the claim should be brought against me, and you can ask the claim, you can seek summary judgment, or you can ask for the claim to be struck out. The problem with that is that on the face of it, there is a valid argument that Mimco has breached a duty that it owed towards her as its landlord, or that it has committed a tort of trespass on her property, acting through an agent, through Watson. So you can say, I shouldn't be a defendant. The law does allow a defendant to say, hang on, you got the wrong person. But this is not that type of case.
Oh, that's not what I meant. What I meant was, I think you misunderstood me. What I was saying was, if the application was to substitute Watson's, or in the alternative, join them, Watson's couldn't refuse to be joined. They'd obviously argue but you can't. I mean, the reason that, obviously, I know that from personal experience. James and I were joined. We had no idea, and the document came through, and we were joined, and we were Part 20 defendant.
I understand that.
So I know
However,
that.
Two points.
I think what James was saying was,
So sorry to cut in again, but I mean, my advice, like I say, it doesn't have to be taken, it doesn't have to be accepted, or maybe it's just not been understood. If an application is made for substitution or joinder in the alternative, I understand that. You're asking for two things and asking the court to grant one of them on the basis that if one fails, well, it's okay because you've got the other one. I understand that. However, an application for substitution is unarguable, and I would be breaching my duties to the court by arguing an application that has no merit whatsoever, and I'm not prepared to do that. However, there doesn't need to be an application to join, because we can simply make a Part 20 claim. You don't need to apply to make a Part 20 claim if it's filed at the same time as the defence. So actually, we don't need to make any application. Would cost money. I mean, it may be that it's funded by insurers, that's fine, so it may be that the cost may not be such an issue, but I'm not going to settle an application for substitution or joinder in the alternative when the application for substitution is unarguable. I have to say, I've never made an application that's unarguable, and I've never argued an application that's unarguable, because it's embarrassing to do that.
Yeah. Have you ever made, when have you done a substitution one there?
I have made a substitution application, and that in that case, the substitution application was to substitute an executrix in place of a person who had died. So a claim was brought by my client, who sadly died, I think about a year ago. The claim was brought many years ago, in fact, but it was suspended because of COVID, and it was a claim for possession of property, actually. And sadly, like I said, my client died, and the executrix of her will wanted to carry on her claim. And I had to make an application for substitution because liability, or in this case interest, the interest of my client had passed to her estate, and the person who was the right person to be bringing forward her claim or taking on her claim was her executrix, because she was appointed
that makes sense,
to the will. So liability is passed means something quite specific in law. It can also be made where someone's liability is assigned, so you can have an assignment, a legal or an equitable assignment. Normally, if you have a legal assignment and one person passes on their liability or their rights and interests to somebody else, I can see how Part 9.
That was what I think James was talking about. So that's speak to Watson and say, look, all that's going to happen here is we, as Mimco, we've got our solicitor and our barrister, so fees times 2. You have your solicitor and your barrister, so that's fees 4 times 4. Whereas this is a small claim. Let's look at going to be able to claim. Why don't you just take it on? We'll step away. I mean, we'll stop spending all this money, and you can do whatever you want, and you can assume the liability for this case. Is that possible? And if they said no, then later on, when there's the issue of costs coming up, you can go, well, we did offer Watson's to take it over. They said no, and therefore that's where we are. And they also can't argue about our defence because they had the option to do it themselves, and they said no. So...
Yes, again, I understand the logic behind that, but a claim isn't, it's not an asset that you just pass on like that. You can't just say to Watson, take this on, or, why don't you take this on? You can do that in the sense you could say to Watson, we shouldn't be on the hook here. You must indemnify us. You must pay us whatever it costs us to defend these proceedings, because ultimately we're going to be coming after you, or Watson should be on the hook. You can do a commercial deal in that sense, but you can't say Watson aren't a party at the moment, so there's no claim against Watson. They're not in the picture. My firm advice is, because I can see there is a claim against Watson, although it's slightly complicated by the fact that Watson might well claim that they had authority from the previous, or one or more of the previous directors of Mimco, to carry out at least some of the conduct, some of the acts that they had.
The email chain, Niraj, have you seen it, where they've said
I have not looked at that recently, but I did see that, I think, on the 25th of August, when I said...
very quick look, I think what they said was, at the very end, they said, we've had the legal advice, and after the legal advice, and this legal advice, it doesn't state who it was why, but it can only be the Watson's solicitors, then crack on. So what they're basically saying is, yes, on your legal advice that you've arranged through your company, who will be defending Watson's. So Watson's effectively did the whole thing. So yes, they did, but that should be indemnified by Watson's and their legal advisors.
We agree on that point, that if it's the case that, well, we agree to the point, because if it's the case that the authority, there was a go ahead from one of the directors of Mimco at the time, and that was based on legal advice received through Watson solicitors.
That's exactly said, yeah. They actually specified that.
Then that's still, obviously that wouldn't make Watson solicitors liable for this claim, to answer for this claim. Assuming that, it depends, it may be that it could be argued that Watson solicitors in fact owed our client Mimco.
That's exactly what I think James was telling me on the phone. But he said it's argued, like you said, you've just been sort of had this thrown at you on the call. But yeah, who knows? The answer is who knows. The point I suppose we're trying to make is here, there is nothing in any of the documents or emails that I've seen that James has sent me. I don't know if he sent me everything. There's nothing that I've seen where, I mean, they actually specifically stated that Beechcroft, DAC of Beechcroft had said, we are not acting. You need to go with Watson's legal advice, then you can go in. And then they said, they reaffirmed later on with the legal advice, which had earlier been confirmed payable by Watson's, and said, yeah, you'll be charging for this. That yes, you can go in, but only based on your own legal advice. So, I mean, what we've got is, for me, what James was saying is the main problem is the contract, in that Watson's and go, well, I carried out with reasonable care and skill because I took on solicitors, and obviously doing that, I didn't go ahead and just go cracking in there. I took legal advice, and the argument back is, oh, we didn't follow it properly. Well, did they? Did they not? I don't know. Yeah, that's the problem. They did. Yeah. I think they did carry it out with reasonable care and skill, and you're on really dangerous ground unless that's pre-covered. I can't see why that isn't pre-covered and why we're actually
anything wrong, and there's no counterclaim being brought against her. What is being said is that it wasn't us, it was somebody else. But actually, that doesn't quite work, because there was some authority given to Watson to do something, it seems. The best we can say is Watson were not authorised to do anything that the claimant claims was done to her property by the defendant, by Mimco. Now, I don't know whether there was pre-action correspondence, whether Ms. wrote to our client or our client directors, Mimco's directors, say, I want to bring a claim against you, or I was caused this loss.
Isn't.
Yes, but that is a very easy way to deal with this without legal proceedings. It's to say, you have trespassed onto my property. It might not have been your fault, it might be Watson, but you are liable for what Watson have done. Can you pay me £500 to compensate me, or can you just put this right and tell me you're not going to come into my property again? And then our clients, James, Mimco can say, very sorry, here is compensation for what's happened. We're now going to go after Watson because we shouldn't have to pay this compensation. So there is a very easy way, and that's what happened. So I'm not sure. I understand how.
I completely agree. However, you know what it's like when solicitors get involved. They'll do whatever they want to do, and they'll take the action which either makes them the most money or whatever. No, I don't
agree with that.
Joe, say something like, didn't you said, like, one of the sentences or paragraphs said that we didn't know about the major works, yet in the part 20 it says, which I looked, and it says in the part, there's like the sink, apparently a sink was stuck to the ceiling, and we've said in the defence we don't know, and in the part 20 we've said the major works.
Yeah, there's no conflict there. What we're saying, this is a fact that's been pleaded by the claimant. We don't know, but to the extent it's right, we're piggybacking on that, aren't we? So we're saying we don't know whether this happened or not, but we are relying on the alleged fact that it did happen to make good our claim against Watson. So there's no inconsistency there in saying we don't know, and then we're telling Watson this is what happened, because we actually don't know. We don't know, but we're pleading. Yeah, and if Watson can turn around and say, well, hang on, you say you didn't know about this, our answer is we don't. We are expecting that Miss will either prove it or be able to prove that fact.
I think Miss has either shown James and Julie personally, and they've been in their flat to see the evidence, or she sent them a video. So, although
that's the case, if that's the case, then we can't say we don't know, can we? We can't say. we can't say we don't.
But you need to tell us these things, because we can't.
That's what we did.
Yeah. So if we know, we know. Yeah, if we know, then there has to be an admission that yes, there is this damage, or there is that these things have been done. But our defence of that is it wasn't our responsibility, or to the extent that we are responsible.
This is the point, and that's
yeah. Well, that's fine. I mean, there is no, like as Emma says, we need to. Those are instructions on facts.
I noticed that straight away. That was what.
Yeah.
I saw what James said, and he was, sort of like, well, surely, if I've seen this, but
I saw that as well in his email, but I wasn't aware of that, so that's why I've pleaded it on the basis of a non-admission.
But I looked at the.
Do you have legal training?
Not really, no. But what I did do was I looked at the. I did a thingy, a law conversion years and years and years ago, like 20 years ago.
But you know a bit.
I don't know anything. I know nothing.
Well, then, but
what I'm saying is,
I've got to say, I'm not that concerned about the Part 20, and I'll take another look at the Part 20 page, and I'll see if I can. If you just let me finish, sorry, I'll see if I can cover off any potential arguments or counter arguments that might be raised. But my main focus at the moment is ensuring that the defence is drafted and is finalised as soon as possible, because we have a deadline that I don't know if it's going to be extended or not. We have to work on the basis it won't.
We're on our third deadline, so I think it's highly unlikely with it.
What happened? I think Julie and James will want to know. I think you'll need to tell them what would happen if they didn't sign a defence.
We've told them. So if we don't file a defence, the other side will apply for judgment. That may only be judgment on liability, but they may be limited in their ability to argue about quantum and costs thereafter.
You mean James and Julie will be limited, perhaps, potentially?
No, MIMCO.
Oh, MIMCO, yeah, sorry, yeah, that's what I meant. Yeah, James and Julie on behalf of MIMCO, yeah, okay, right, so they know that, but, yeah, so, I mean, I don't know, I suppose, is there anything else that you want, or do you want to just crack on?
Can we talk about a few practical points? The first one is that I've been asking for weeks now for James and Julie's identification documents. I must have them by the end of today. Yeah, because we can't.
Has Julie not sent hers over? I'm sure she said she sent it. No, she not. No, I don't know. She can't talk either, can she? So, but so let me just.
They must come. I must have those today.
Well, hang on 2 seconds, because I'm going to end up, if there's something I actually need to pass back. Hang on. One. Hang on. Bit of a remedial typer today.
Do you know which one of them is going to be signing the defence?
I don't. I know that obviously you want to put the name on there, but
because I think we need the ID documents for whichever one is going to be signing it.
ID docs for.
Ideally both, but.
I know that in an ideal world you'd like it today, Emma, but reality is if they can't for whatever reason, Monday's going to be okay, isn't it? By today, I'll put today. But
no, I need it today because we've got to run it through our system. This should have, as I say, I've been asking for it for weeks, so I would like it today, please.
Okay, I'll tell them. I'm not, obviously that's out of my control really. But ID docs for whoever size. What do they need? Do you know what?
A copy of their passport or photo driving license and a utility bill within the last 3 months.
Last 3 months utility. Does that include bank statement they can print off the internet?
No, it'd be electricity, gas. Phone probably be okay. Council tax,
gas, council tax. I don't know. Maybe Julie can provide. I would say that James is definitely not going to have access to anything that came through the post. He's literally been in and out, and as I said, he's in the Philippines on Sunday for business. So
right.
I don't think he's going to have access to anything. If he can print it off the internet,
well, he'll presumably have a phone and his passport with him, so he can send the passport through.
His passport he can definitely send through. His phone, I know his phone is a business phone because I have the same one. So that won't, and the address for that is our head office.
No, but he can take a photograph of his passport.
And do that. Yeah. But in terms of, I mean, what I'm saying is, you're saying utility. I guess he's got a bank statement. If that's not good enough, I'm going to have to fall back on Julie, I suppose. But I don't know. But if she's got that, I guess she might have.
The bank statement will probably do the trick. At least it would be a start.
Bank statement. I'll put that in brackets. Then I'll remember what I meant.
So the next thing is, in terms of signing this document, is James going to be on email and able to deal straight away with approving the defence? I don't know, Niraj, when are you likely to be able to get us the draft? Sorry, I know you've had this foist on you just today, so...
Yeah, well, last time I think I was drafting in the early hours of Saturday morning.
I know, you were.
August,
yes,
so
you were.
I can fit this in over the weekend at some point, make sure it's ready for 7 o'clock on Monday morning. But what I'm a little bit concerned about is going through again just now some of the comments on the defence. On the one hand, it's saying, why don't we just deny everything? On the other hand, saying, well, we know X, Y, and Z happened. I mean, I need very clear instructions if any part of the defence is not accurate. That is factually inaccurate. I'm concerned that there are things being said now. For example, that we know a sink was attached to the ceiling. We can't be sort of thrown curveballs. I need to know exactly.
I think we need that today. We need today a list of points that are inaccurate in the defence. Not that where there's an ideological difference, but points where it is factually incorrect. We need that today, don't we?
I can't do this on Monday morning. Realistically, I need to do it before Monday morning, so it needs to be done today.
Yes.
I mean, I would like to think there isn't very much there because obviously I haven't invented stuff. I've been putting into defence the instructions that have been provided to me. But where those now seem to conflict with the email that I saw earlier this afternoon, we need confirmation because I can't. Ultimately, I can draft something that might not be accurate. That's not a good thing, but it could be that's not my fault. Someone can't sign a statement of truth that they know to be false because that is extremely problematic, and that would be a contempt of the court. So it's not really that doesn't become my problem because I've drafted what I was told. It's just that what I was told was wrong and known to be wrong. That's when it becomes a real problem.
Yes. What I need to do, ask Julie and Jay,
it would be helpful.
Fact check.
The way to do that, actually, probably the better way to do that is to go through the particulars of claim, and maybe sometimes it is as straightforward as going through sort of sentence by sentence in the particular claim. Yeah, yes, we know that, or yes, that's true, no, that's false, because I will draw my pleading in the defence from the instructions on the particular claim. But at the same time, if there's anything in the defence that is currently wrong, it's really important that I know that so I can...
So going through the claim and saying, hang on, fact check, 2 seconds, go through the claim, paragraph by paragraph. Sorry, I'm a terrible typer.
It's fine. I mean, I should say, I know you're typing.
Go back, and what do you want them to do?
Instruct me on what is accepted as true, what is incorrect, or what is not known. And that has to be completely accurate. So if someone knows something, or they think they know, and they say they don't know, then that's a problem because that's not valid. You have to be able to...
I think you're right. I don't think there's going to be much. I think you've probably just picked up on one point and put it in, which you could be forgiven for not knowing if you'd not been given the information. So
right.
I get that.
Yeah, it may just be that one point, which is where we
it might be.
Yeah, we did enter the apartment. We know exactly what works have apparently. But it's a bit odd. It says we know exactly what works have been apparently carried out. Well, we don't know exactly. We know that's what Miss have said.
Yeah, that's what I was trying to say earlier, Niraj.
Yes.
We all we know is what she said. She might have done it herself. She could be lying. We don't know. But the point is, that's the whole point. That was the whole premise of what James and Julie getting concerned about. It's like, we just don't actually know at all. So the
We
fact
don't-
that we then
yeah.
say,
Yeah, we don't know. I mean, if they've gone there and perceived it themselves, they've visited them to her apartment and said, look and see what Watson did, and they've seen it for themselves, then it's impossible for me to plead that we don't know. We don't know what the current situation. We don't know who did it. Maybe we don't know when it was done. Maybe, but we do know that is what has been done. Or there is a sink on the ceiling, for example.
Absolutely.
Now,
They've either seen the video
clear with
or
that.
they've been in the apartment to see it. I don't know for sure.
Yeah,
I can't remember whether they said video or they've seen it or they've showed or they took a video when they were there, but they've definitely either seen the apartment with the sink or they've been in or they've seen a video. So, but at the same time, who did it? We don't know. It could be somebody else.
Well, we know we don't. Yes, I mean we know who it's likely to have been, and we do actually say whatever's happened is Watson's responsibility. But if we know, then we can admit, yes, there is a sink stuck to the ceiling, and yes, Watson did it. If we can say that, then fine. I mean, that's great, because that actually avoids the need of her to have to prove it.
Hello.
Yeah.
Hi.
Julie.
Sorry, I've had to go upstairs and work because I'm on a free phone order line. I'm really sorry. I've just heard now. I've just come back downstairs to see if I can join this. Miss most of it, obviously. What are you saying about a sink? Sorry.
Yeah. So what it is, they say in the defence they've said that they didn't know about what happened, and I said that either you and or James had actually been in the apartment or seen a video of the sink set up.
It was put on social media. Everybody saw it. It was on a Facebook page, and a lot of leaseholders saw the sink that was attached to the ceiling and the pipes going down to a sink. It was public. It was public to people.
Wow. Yeah, but you've not seen it personally, though, no?
Yeah, I saw the sink. I've seen the sink on when I went to view the apartment to see the state of it. I saw the sink. I think at that point it had fallen down and on the floor, and there was more damage. Yeah, I've seen the sink on the floor, but it was on social media. The sink was on social media to say, look, what's happened to my apartment.
So
Did you and James see it on social media?
You'd have to ask James if he saw it on social media. I saw it. I saw it on social media prior to being a director, but I only came on as the director on the 7th of July to help with the admin side of things, and then obviously a load of directors resigned. So, but I have seen the sink, I have seen the apartment, but as for the case, I know the leaseholder because the reason I know is because she got hold of me again via social media to make me aware about 12 months ago, to make me aware of what was happening in the mill, because I had no idea. I had a good tenant in, I was a leaseholder, but I did not know the complications. I didn't know anything about the leak. Hence, I asked, could I go and view for myself? This was prior to me being a director, just as a leaseholder. So that's my interactions, how I know.
Right.
I know fellow leaseholder. And and then when the old board was out and the new board was in, then into that they were struggling with the admin side of things and asked would I be co-opted on, and I agreed to it, which obviously now I wished I hadn't, but that's another story. So it is
I apologise for interrupting. I have another call. Actually, it should have started 15 minutes ago, so I've got to speak with another client who's booked in a conference some time ago. I think I've got what I need, but it would be helpful. I've got what I need now, so I'll go through the email again and see what changes I can make to the defence. But I don't want to be doing that exercise twice. I've already done it twice. This will be the third time. It'd be really helpful to have clear instructions on exactly which parts of the particular claim are admitted, because they've been perceived or we know them to have happened, which bits we don't know about anything at all, and which bits we completely deny ever happening. And I think the only thing we deny happening is that Minco is responsible for all of this. But I just need to know that, because otherwise I can't do my job.
Can I just ask a question then? How do I, is not being aware of a lot of this, how do I go about that? Because I can't sign something that I'm not aware of that's not true, can I?
No, you certainly cannot sign something that you're not aware is true, and you can't say it's true. I've not got very long, unfortunately. We have
overrun.
Not very much time left.
Yes, I'm so sorry. It's just that I have a day job and I can't get out of it.
Yeah, so there is a document called the Particulars of Claim, which is how the claimant sets out what she's claiming. For example, she says she's a tenant of the apartment known. That's a fact that we can admit. We know she's a tenant. At least she might not live there all the time, but she's got a lease of that flat, that apartment. So we can admit that, and we don't need to worry so much about that. But where she says something like, for example, on the 11th of December 2022, at between 2 a.m. and 3 a.m., the claimant arranged to attend the apartment. I'm not sure whether we know that. We know that's what she says, and she may have told you that, or she may have...
No, I'm not aware of
that. Yeah, if we're not aware of that, we just say, well, we don't know. I mean, that's what she said she's done, then fine, she has to prove it, and she can probably prove it by saying, I asked my partner to attend it that long. If it gets that far, it won't.
I'm just thinking
he can come along and say, yes, I did. My partner told me to go along. So that, can you say that's just an example? But the key example, or the key points are the damage that's pleaded in paragraph 7 of the Particulars of Claim. And that's what we know about...
I'll just really stop you quickly. Would you, rather than asking them to do it, would you be able to ask for clarification on the points? Because if you said...
No, I think we've got so little time, they're going to need to do this straight away. I'm sorry, but I don't think we can make Niraj do another task.
Want me to do it? I mean, I've already thought I had instructions actually on all of that, and it looks like some of those may be accurate, some may have been inaccurate. The way to do it, actually, because I can see somebody's taken a photograph of this document, so what they can do is they can, if they could print that out, and they could even go through and put a tick or a cross or annotate the particulars of claim to tell me, for example, yes, that happened, or I'm not sure about that, or we don't know, or yes, I've seen that damage, or yeah, that was on Facebook. Something like that would give me enough factual instructions, factual information to be able to ensure that the defence.
Okay, that's a good idea. Yeah.
I'm really sorry. I've got to go. I didn't mean to rush it, but I've got forward.
Thanks, Niraj.
My client's list is on the other call. But we can perhaps pick this up early next week once you've got, Emma, once I've sent across to you the next draft of the defence. That can be by sort of 7 o'clock in the morning on Monday or 8 o'clock in the morning on Monday.
Yeah.
But that really has to be the final version, almost the final version, because...
Well, particularly if James is signing and there is a time difference.
Yeah, I don't know when he's flying. I've not been able to speak to him yet. He did try to call a minute ago. Right. But yeah, all right. So okay, Niraj, yeah. So you're thinking 8 o'clock Monday morning, yeah?
That's what time I'll be able to send through an email to Emma. And I appreciate you may not pick that up until a bit later that morning. But that's sorry.
When do you need these comments by?
Today.
Today.
Yeah.
I will be working on this. I'm planning to work on this very, very, very late tonight. Yeah. I don't have any time on Sunday. I can possibly work on this tomorrow. Ideally, I'd rather not be, but that's just the way it is sometimes.
Do you mean by 7 o'clock or 8 o'clock? When's the latest you need it by?
By midnight.
By midnight. No, sorry,
I think you'd have to send those through directly to me. Emma, I don't mind if that comes through directly to me, but you must copy in solicitors so that they've got a record of exactly what's been sent across to me.
I'll forward the particulars of claim onto everyone, and I'll copy Niraj into the email so that it's around.
Do you think you'll be able to do that, Julie? Just sort of have a look through and factually check it.
How can I factually check something I don't know about?
Well, if you say
no.
So I just.
Niraj, shall I finish off, Niraj? Because if you're late for your other,
Thanks, Niraj.
Well, thank you very much. Nice to speak to you both.
Thank you very much.
Bye-bye.
Bye-bye.
Okay.
So can you hear me, Julie?
I can, yeah.
So what the court rules require in terms of a defence is you to go through a particulars of claim, and in relation to each element say that's admitted, that's denied, or sorry to say in relation to each assertion that it's either admitted or denied or you don't know.
Okay.
So that's the exercise really that Niraj has asked for with the particulars of claim. So I think I don't know if you've,
wasn't it, Emma, as well? You wanted that
and the defence, yeah.
Holder, you know this year, so you can say yes, you can tick that, and then put no, or put a question mark, I don't know, maybe circle or whatever.
But isn't there going to be a difficulty in that James has been a director for longer? So isn't James the person who's likely to know more than Julie?
Perhaps, yeah.
So James needs to be doing this exercise too, because he's been around for longer.
Yeah, I suppose, yeah. Yeah, well, sorry, Emma, I jumped in. You carry on with and explain to Julie what she needs to do, and then we'll answer your question.
So I will send a copy of the particulars of claim to you, and I'll send it to James. It sounds as though you're not going to be able to do a joint effort, but we need a commentary sort of paragraph. It's not very long, paragraph by paragraph of admit, deny, don't know. Does that make sense?
Yeah.
Yeah,
okay.
Cool.
Good.
Okay, right, so do you want to do that then, Emma? And is there any other business?
Well, just while Julie's here, I'm really concerned. I need your identification documentation and James's identification documentation.
Both of them or one of them?
Well, I'm sure you can only provide yours, but I really should have both, and I'll need. Are you proposing to sign the defence, or is James?
I wasn't proposing to sign it, but I don't know whether I haven't spoken to James because I can't get hold of James.
Because if James is in the Philippines on Monday, and we're getting the draft,
he told me he was flying Monday. I don't know how long the flight will be. I guess it's 10 hours or something, isn't it? That sort of time.
No idea.
I don't know. I've never been to the Philippines. I've been to India. That was 10 hours.
One of you will need to sign the defence.
Otherwise, you need.
Otherwise, it's not completed. It's not done.
Yeah. Oh no. But I think I don't know whether that just effectively, if one of you doesn't sign, Julie, what they're saying is that the case will be lost and Mimco will have to, and also the insurance might not cover you because you're not sort of done your best, if you like.
Or you're done.
Julie hasn't read the defence, unless you have, Julie, have you?
No.
Only James has read the defence, and what he was saying was he was speaking to Julie. That's what he was saying. And on the other claim, Julie's already refused to sign something which Fowler has prepared because of it. So I suppose James probably just guessed that she'd be the same on this one, if you see what I mean. But I don't know. Maybe not. Maybe it was James being overly sensitive, but he said he wouldn't sign it based on that. He said there's no way he was going to sign it.
Right. Just to be clear, though, Julie, I'm afraid that the position is that if Mimco through you and James reaches a stage where you say, well, we don't want to sign the defence, we don't want a proper, fully formed defence, the kind of defence that council and Radar advise is the appropriate defence, that would put Mimco in conflict with AXA.
I understand.
And we would not be.
That.
I'm sorry, we keep having to have these sort of very bald statements, but it is for a claim that's relatively small. There have been lots of kind of quite complicated strands, which I really hope going forward we won't have to have that. And Julie, it might help if I had if you were prepared to give me a mobile number or so that we can, because it's been much more useful today. Actually being able to speak to you. I appreciate that it's difficult when you have a volunteer directorship position and a full-time job.
Yeah.
Okay, so I think we've got a bit of a plan. If you can get me your identification documentation, Julie, so at least I have that. That would be either a copy of your passport or a copy of your driving licence, photo driving card. And a recent utility bill, that would be helpful. I'll need the same from James, or as best as he can do, given his travel. And then I'll send the particulars of claim for you to mark up. And and get back to me. I will copy into the email Niraj's email address, that's council's email address, so that when you reply, you can copy him into the reply. Normally, there's a somewhat archaic, but still necessary sort of protocol that you give instructions to me and I then pass them on to council. But given the restraints of time here, I'm going to need you to copy both of us in, please. Does that make sense?
The idea I understand. Yeah, I'll probably have to go through I'll probably have to go through the thing with you, Ed, to understand it. I'm sure something. Yeah, but yeah.
Yeah, I can help, I suppose, if I can, or maybe we'll speak.
Ed,
to James.
Do you want me to copy you into the email as well, Ed?
It's okay if you just send it to Julie and James. Reason being, they've had various people saying friends of the ex board talking about data protection. So I don't want to really be included in anything. So. You see what I mean? So
just
happy with James and Julie's fine.
And Julie, the best address for you is the inquiries one I've been using.
Yeah.
Yeah. Okay. All right. Good. Okay. Well, there's a bit of a plan there, but it is really important that we get this knocked on the head, and that we carry out those steps as agreed, because otherwise we're going to be really, in difficulty. I know we were extremely lucky to be able to get Niraj and just to collar him as he came out of court today, and that he has a bit of time available tomorrow morning. But if we miss that, we're going to be in real difficulties.
Yeah. Okay. Right. Okay. So okay. I think we're probably okay with that. Is that right, Julie?
Yeah, I can't.
Or do you want to ask Emma? If you want to ask Emma anything, then I suppose now's the time.
So I just go through sort of point by point, and I mean, obviously, I do know about the sing, but what if I'm not aware of those other things? That's what.
So if there's something you're not aware of, just say don't know, because what else can you say?
Well, I can't.
But what
it's not going to look very good, is it?
No, but I think councils. Yes, that's fine. It doesn't matter if you don't know. James might have a slightly different position, which is why I want you both to do it. It doesn't matter if you don't know. What does matter is if, for example, like the sink, we say in the defence, we don't know when you did.
Yes. Yeah. No, I definitely know about the sink.
So the defence, to a certain extent, the defence doesn't really matter that you don't know about things for the purposes of the defence, because the main thrust of it is, well, it was Watson's fault. So what you know doesn't, but it just must be right, and we don't want to have some little point where you've said, "Oh, we don't know when you did," being used as a sort of hostage to fortune.
Yeah, no, that's fine. No, I'm totally with that. I can, I'll know from reading it what I know and what I don't know, basically. Yeah.
Fine. Good. All right, I'll get that across now.
Okay.
Good. All right. Thanks, Emma.
All right. Thanks, Julie.
Thank you.
Thanks.
Bye.
Bye.